Hey, come back, Mr. Taylor. Come here. Let me tell you something. I still have jurisdiction over your case. So any disrespect that you show me right now, I can add years to that number. Is that what you would like to do?
This is one of those cases where the outcome feels heavy before a single word is spoken. You can tell immediately this isn't someone new to the system. This is someone the court has seen before, and that changes everything.
Good morning. You are Jimmy Taylor?
Yes, ma'am.
And Mr. Taylor, you were previously in court, entered pleas of true and a motion to revoke your unadjudicated probation. Counts 1, 2, 3, 4, 5, and 6. You pled true to all of those counts. You're on probation. The second-degree felony offense of theft of property with previous convictions with findings that prior offenses were true. You were placed on that probation January 24th of 2024. I have received the pre-sentence report as well as there was one incident report from the jail, a page that should have been sent to you all, and also Mr. Coleman has also provided a copy of the court's sentencing hearing, a transcript from that original sentencing back on January 23rd of 2024. Has everyone had an opportunity to review all of those things?
We have, Your Honor.
State has, Judge.
Are there any additions or corrections to that updated report?
Not from the defense.
Not from the state, Your Honor. There are a couple of things I'd like to speak to if and when the court would like to hear from you.
Yes, of course. So let me just, there's no agreement in this, correct? This was just open to the court?
That's correct, Your Honor.
Yes, Your Honor.
And, all right, Mr. Rojas, you may proceed.
Thank you, Your Honor. We're going to be asking for the court to continue Mr. Taylor on probation. I know by looking at the PSI on paper, it doesn't look like there's a chance that Mr. Taylor should be given, especially given his criminal history. It looks like his criminal history is all in some way related to drug abuse. If you look at the allegations he pled true to, those are the non-compliance allegations have to do with drugs. And the reason for not complying with the JCBI program, he doesn't come from a wealthy background. He doesn't have a whole lot of affluent friends and family members that can help him out. He had a ride with his brother. His brother had an accident, and that option was not available to him anymore. He indicates to me that he does want help getting off of the drugs, and I'm sure that when Mr. Coleman has a chance to speak, he's going to point out the comments made by the court to this defendant about not wanting to hear about needing more help with drugs or any relapses.
When the judge starts pulling up past reports and reminding him of ISF, SAFP, parole, prison, that's when you realize this isn't about one mistake. 23 years out of the last 30 in prison. That number hits hard. And what really stands out is that she didn't have to give him probation before. She could have sent him away for 10, even 20 years. Instead, she took a chance. Judges remember when they extend mercy, and they remember when it doesn't work.
I really don't, because here's the thing, Mr. Johnson. I'm looking back at your original pre-sentence report that when I put you on probation, and I make notations on those reports and make highlights and those types of things. And I'm noting that in that report, you already, before this case, had gone to ISF and SAFP. And then on this probation, I sent you to ISF at the beginning of the probation. Is that correct or no?
I believe parole sent him to ISF.
Yes, ma'am.
So you were on parole.
Yes, ma'am.
I gave you a probation against Mr. Coleman's wishes and really against what looked like I should have. You went to ISF regardless of who. So you've been to ISF twice. Is that correct? You're looking at her. You've gone. Have you been to
Yes, ma'am.
ISF
I've been
once
to
or twice?
How many times?
How many times?
Twice in 20 years.
Okay, so you've
I've
been,
been in prison 23 years out of the last 30 years. So I've been doing my time, and
but you
I
keep
haven't
getting,
had a chance to,
to do what? Because you've been to SAFP, you've been to ISF, and you went to ISF more recently, right?
Yes, ma'am.
Okay.
As soon as I got out, I got right on probation. And I haven't had a chance to
You got right on probation. You didn't,
Yes, ma'am.
you
Then I
tested,
had to go to Beaumont, which
you
I'm
tested
from,
positive for
Colorado.
cocaine
Yes,
after
I
all of
understand.
this time and all the different things that have been given to you and the opportunity that I gave you back in January of last year. You pled open, just open to me. I could have done
Yes, I did.
anything.
Yes.
I could have sent you to prison for 20 years, 10 years, and I gave you an opportunity. And I said on that day, because Mr. Coleman printed it out for
I know
me,
what you said.
well,
Ma'am.
so how do I do anything other than what I said?
I mean, it's a situation.
The moment he brings up his 90-year-old mother, you can feel the courtroom shift. That's emotional. That's human. But the judge shuts it down immediately. Because from her perspective, that argument isn't accountability, it's deflection. And in probation hearings, accountability matters more than sympathy.
Situation. I've got parents. My mother 90 years old, man. I don't want her to die and I be
Hey,
in prison.
we're not talking about anybody
You
but
know
you
what?
today.
Yeah, I know.
I'm sorry your mom's that old and that you
Yeah.
haven't been around to be with her, but that's whose fault? It's not going to be my
I
fault if
understand
you're
what
not there.
saying, but
How about some personal responsibility instead of my mom is
that's
old
what
and
I
don't
would
send
like
me to
do,
prison?
ma'am, you know.
Judge, what I was saying about this.
Go ahead.
He was warned about not coming back, and the court didn't want to hear about a relapse, but I don't know that this is really a relapse. He never really got the help. On this most recent term of probation with the JCDI, and if transportation is going to be a problem, I know he's already been to Safe P, Judge, but it would be the relapse portion of Safe P would be appropriate, or a whole new term.
Hold on. So if I'm reading this, I want to know when he went to ISF this last time. Parole sent him when, because the way I'm reading is you were released from ISF and started JCDI August 6th of 2024. So I put you on probation in January, and between January and August, you went to ISF last year. Is that correct or no?
Rose sent him to ISF because of this new charge.
Okay. So when was that?
He was in custody in Jefferson County, and then from custody.
Went straight there.
parole,
So I placed you on probation. You never got out. You went and got help at ISF. Okay. All right. Anything else?
And Judge, if the court, and it seems like the court is not leaning towards probation.
No. No.
I would point out, we understand the range of punishment is up to 20 years, but the bottom line of that range is 2 to 20. And
I still haven't done anything yet. So your response and how you act right now is going to go into what I do.
Now here's where it gets complicated. The underlying offense. About $100 worth of merchandise from Dollar General. On its own, that doesn't sound like something that equals 12 years. But this isn't about the dollar amount anymore. It's about repeat behavior. Prior convictions, drug violations, failed opportunities. Probation isn't just freedom, it's a test. And the prosecution is basically saying he's failed every version of that test.
Now, I understand the legislation makes it possible to go all the way up to 20, but it also makes it possible to go down as low as 2. I think we have to look at each case for the facts, and the underlying offense was a theft at the Dollar General, I think, or Family Dollar, I think it was about $100 worth of merchandise. I would ask the court to consider something at the lower end of the range, maybe 2 to 5. Just because we can drop the hammer on them, that doesn't necessarily mean that we should. And that's what we're asking the court to do. Probation is not going to be an option.
Thank you. Mr. Coleman.
I'll keep it brief. The defendant has earned every bit of a 15-year sentence in prison. That's what I asked for originally. You placed on deferred. That's what I'm asking for today. 3 things I'd like to quickly point out, Your Honor. Looking at the defendant's version in the updated PSI, he says that when he was placed on in the JCDI program, that he believes it was an attempt to set him up for failure, demonstrating a lack of acceptance of his own responsibility. The resources and time that have been dedicated to this defendant, limited resources, mind you, could have been redirected to someone who is more amenable to being rehabilitated. Lastly, you got his full criminal history there in the original PSI. And I provided you with the transcript from the sentencing just to remind the court. I know you see a lot of defendants, but just to remind the court that you essentially told him up front. This was essentially a zero tolerance probation.
And I do appreciate that because I do see a lot and I don't remember it all. But Mr. Taylor, do you have anything you want to say?
When he says, "I've done my time," there's something almost tragic in that statement. Because technically, he has. But prison time only matters if something changes afterward. And the judge hears the same word she's probably heard dozens of times before. Give me another chance. At some point, the system stops believing promises.
Yes, ma'am, you know, been through a lot of things in my life, you know, people dying in my family and other things, drugs, but, you know, I think, you know, that I could do better if I had a chance, proper opportunity, ma'am. And
Mr.
I did a lot of time, I've done my
Yeah, I know.
time.
You have.
I
You've
don't
done.
think just putting me in prison I think I need
But
a chance, I really
Well,
do.
it doesn't make any sense because you're saying, you've done a lot of time. And at some point, you either say, I don't like prison and I want to do better.
That's what I want, man.
But you didn't take advantage of the opportunities you were given. You're saying you want help, and we gave you help, or parole gave you help. So you didn't even get out on my probation yet. You had ISF, a reminder of the tools that you had a long time ago. You had those things, and you got out, and you didn't take advantage of the opportunity that I told you. You better take advantage of it because you're not going to get it again. You're saying the same things that you said. Please just give me another chance. I'm going to do better. Please send me to ISF or a safety. It's all the same thing that you're saying, and no one is setting anybody up for failure. Hang on.
To the JCDI. I had back surgery.
So what you're telling me is when did you have back surgery?
8 years ago.
Okay.
But they only did half.
Listen.
I'm not making excuses.
If you're throwing out to me that you had back surgery 8 years ago, then you are digging for everything you possibly can, and we're done with all that.
12 years. Not the 15 the prosecutor wanted. Not the 2 to 5 the defense asked for. 12. That tells me something important. She wasn't trying to max him out. But she was done negotiating.
All that. I'm going to find that you previously entered your pleas of true to counts 1 through 6 freely and voluntarily. I'm going to find those counts true. I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. I'm going to sentence you to a term of 12 years in the Institutional Division of Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you trial court certification that shows this was not an agreement. You do have some limited rights to appeal. You can talk to Mr. Rojas about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. Y'all need to sign that, and he'll give you a copy of it. Thank you. Thank you, ma'am, for being here. Ms. Holmes on Demario Flukas.
That's just fair. It looks to me 12 years.
Hey, come back, Mr. Taylor. Come here. Let me tell you something. I still have jurisdiction over your case. So any disrespect that you show me right now, I can add years to that number. Is that what you would like to do? I do think it's fair. It doesn't matter that it's a misdemeanor. You keep doing it over and over. Go back with the bailiff. And you probably should keep your mouth shut this time.
And then that last moment. He says something under his breath. We don't even fully hear it. But the judge calls him back. I still have jurisdiction. That wasn't just a warning. That was a reminder. Even after sentencing, how you carry yourself matters. Because in court, respect and responsibility are everything. And once a judge believes you refuse to take responsibility, mercy becomes very rare.
This is the bond forfeiture docket, Nisi, case number 24 DCCV 1018. And I guess these are both kind of similar issues with regard to the same bonding company, correct?
I think they're identical.
And then 24 DCCV 1321. Mr. Kelly or Mr. Romano, what's,
On Mr. Celestine, and again, I think the issues are the same here, is that the defendants in each of these cases, in Mr. Celestine's case, he was ordered, I think by the court, to get a drug patch on one setting, given 24, 48 hours, go get a drug patch, come back, or give us notice that you've done so, and for whatever reason didn't. So my interpretation of that is a bond that should have been revoked by the court, not forfeited, or left Mr. Romano and his company responsible. As an issue between Mr. Celestine and the court. I think the issue is the same.
did I, well, I mean, if he,
You ordered it in court one day. He apparently showed up to court, and we weren't notified at the jail that he had to have one. So his first stating, you showed up and said you need to have a drug patch within 24 hours. It didn't get done. We didn't know it didn't get done, and so the next court date we moved the hearing up, and he didn't show up to court. So that's kind of the issues on both of these.
but if I had, did you not know about the court dates? I mean, regardless of, if there's a bond violation, a lot of times what I'll do is, if it comes to my attention through, Ms. Werner will get the emails from whoever it is that they're supposed to have a GPS or a drug patch. And then if I get some type of referral back from them that says either they're not wearing it, or they didn't get it, or they tested positive, sometimes if it's a positive, I'll at that point just raise the bond and do an at-large without proper bond. If sometimes though, instead of waiting till the next court date for these violations, I'll move it up a week or two. So I guess if I moved it up, which is what it sounds like for a bond hearing, just a review to see what's going on, are you saying you didn't know about that date?
No, we knew about the court date. What I'm stating here is when we did the bond, the drug patch was not a part of the bond that we did with the client. That was a condition between the court and Mr. Celestine on this actual situation.
Right.
And basically, what I'm saying here is some of these bond conditions are setting us up for failure. I mean, like this guy, you gave him 24 hours to get the drug patch put on. Okay. But he knows he didn't get it put on 24 hours later like he was supposed to. So at that point, it should have been either at large without proper bond. I mean, even if we want to do judgment nieces, they can be defendant onlys, because we're the ones getting punished here for bond conditions that when we post these bonds at the jail, we don't have much to know about. I mean, the next guy violated 18 times bond conditions that we didn't know about until the day of the hearing that he forfeited on.
Young man, respond.
Yeah.
There's a couple of things. Number one, if the bondsmen want to know what conditions, what changes are being made here in the courtroom, they should attend the hearings. It's not appropriate for the court to.
Well, let me stop you. I think the conversation that we need to have is probably something that we need to have maybe at a bail bond board meeting, where we can address if and how those conditions can be relayed when we do them here in court to you guys. But the thing is that's every court does it differently.
Yes, ma'am.
But the court date and the bond forfeiture, it is what it is. I mean, they didn't show up. You're not saying you didn't know about the court date. And so I think regardless of why I set something, whether it was because of a bond issue, that to me, we're talking about two separate things. Somebody didn't show up for court because of a violation of a bond condition, but they didn't show up for court. So that's a forfeiture. If I know, it's just different on how, it depends on, for me, how I handle them. And we can talk about that later.
So on the next one, the state even filed a motion to increase or revoke. And we set a hearing for that. He had violated 18 times. We didn't have any notification from the ankle monitor business. And we have no grounds to drop him when he is violating those conditions.
No, I understand that y'all might need some type of, I understand.
So I'm asking some kind of relief, because this next, I mean,
Well, I don't know that I knew someone violated 18 times.
I didn't say you
because-
did.
No, I'm just saying, I don't know that either of us
Yeah.
knew that, because if someone's violating an ankle monitor 18 times, typically it's going to
Somebody's-
immediately be at large without proper bond, not just let's reset a hearing for a week out, because I would be concerned about that. So sometimes we may not get it from the company until they say, oh, look, there's been a whole lot of these. And so we don't know that either. So that's obviously something we need to take up. I guess,
John, if I might respond.
yeah,
Section 2213 does not list the court changing bond conditions as grounds for exoneration on the bond. I mean, it's simply not there. I mean, it's, the court has to address the defendants as the defendants appear in the court. The bond conditions for the jail, right now, Mr. Romano has not told the court that they can't go over to the jail and pick up a copy of the conditions that are placed on them at that time. I don't know why they're not getting communication from the
well, no,
ankle
he's
monitors.
getting them, they're getting them
It's fixed.
when they're initially done.
Yeah, it's fixed now. That issue.
That's been,
Okay.
yeah, we've been working on that.
Otherwise, they
But
can
what
attend
he's
here.
not getting is their information here. And I understand that they can't also be in every court every morning. There's, I don't know how many people they have working for them, but we've got 4 or 5 courts going on. So I understand that there's an issue potentially with getting that information. I don't think it changes legally, though, the fact that there was a court date, knew about it, the defendant didn't show up for that court date. And so I don't think legally there's relief necessarily that I could give unless there's some agreement to that. I do understand where you're coming from, but I think the fact that y'all knew about the court date, there wasn't some communication issue with knowing that he had to be here, or both of them were guys, that they had to be here, and that it didn't show up. I understand what you're saying. If you knew that there were those violations ahead of time, maybe y'all would have filed an AFRS or whatever.
That's part of what my thing is. We can't. We do bail bond agreements with these people, and it spells out what grounds we have.
Right.
These violations have to come from the court as far as the issuing of warrants, and I can't even go rearrest them. We have a investigations company, but I can only go pick up on our forfeitures. So even if we do it at large, my hands are tied on some of this. And Mr. Price just wants us to keep going after these people, and I understand that. But even on this kind of situations, I can't go after these people. I can't even issue a warrant for them. Legally, I cannot, because they could come back at us and go, well, here's what our contract says. Well, the bond conditions were not part of our bail bond agreement.
Well, what if, we need to talk about that later too. Make a note, because why can't y'all put in your bond agreement that it's any bond conditions that are there and any bond conditions that the court orders?
That would be something we have to do after the fact. So sometimes, like now, we're knowing bond conditions. This isn't an issue that's going to keep coming up because they fixed it at the jail. But this is some of the old stuff that we didn't know until we get blindsided. Like,
So were these my conditions on both of these, or were these conditions that were, because I think that is different. If these were conditions that were placed by the magistrate at the jail, or were these conditions that were placed on them here in court by me?
I'm sorry, Judge, on Mr. Celestine, I believe that was the court's
yeah, that was the court's.
on the drug patch.
Okay.
These were the court's standard conditions because they're
One's a
general
felony.
violations anyway.
Mr. Ortiz, I think, is going to be yours also.
Okay, so these weren't the jail issue. Okay, all right, then I'm going to grant the forfeitures in each case, and then we can discuss somehow, if I get with all the courts though, to figure out a way to get bond conditions that are placed on them after the fact by the court, which happens all the time. And so I don't know, really, other than y'all being here, but we can try to work something out. But I don't think that's necessarily the issue's going to be getting everybody to do with the same. But we can talk about it at bail bond board. All right,
Your Honor, just for clarification, I would ask that the court take judicial notice of the court's bond forfeiture docket for the cases thereon,
we'll do so.
and take judicial notice of the bond forfeiture case and the underlying criminal case in each of those,
We'll do that as well.
and enter judgment according to the court's docket.
I will do that as well.
We have final judgments prepared for that, Your Honor.
Okay, thank you.
Thank you, Your Honor.
All right, and hey, remind me, and we'll try to figure something